Welcome back, everyone. I hope you all enjoyed your lunch. So my name is Finn Fehrenbach. I'm a first-year student here at Colorado Law School, and I'm excited to introduce the next panel, AI in the Interpretation of the U.S. Constitution and Other Legal Documents. Here, panelists will explore the potential risks and promising benefits of using artificial intelligence in the context of legal document interpretation. I'm super happy to announce that the panel will be moderated by Professor Harry Surden, an expert in artificial intelligence in the law and the faculty director of the Silicon Flatirons Artificial Intelligence Initiative. Without further ado, I'll pass it over to Harry Surden.
Thank you so much, Finn, for that kind introduction. So I think we've got really fascinating and timely, and maybe one of the only panels of its type in the country on using AI to interpret legal documents, such as the U.S. Constitution or other documents such as contracts. What I'm going to do is introduce our all-star panel, then give a little bit of overview before opening up questions to the panel. But let me start going in just in order here. And these are very accomplished panelists, but in the interest of time, I will only provide very short biographies, but I encourage you to look at their more extensive accomplishments, which are linked online and also in the program. To my left is Yonathan Arbel, who is Silver Associate Professor of Law at the University of Alabama Law, has done a lot of really interesting work on AI and contracts, and is a well-renowned scholar. Next to Yonathan is Megan Ma. Megan Ma comes from Stanford University at the Stanford CodeX Center for Legal Informatics. Megan is an expert in AI and linguistics, and one of the leading thinkers in this field. Next to Megan is Vivek Krishnamurthy. Vivek, thankfully, has joined our faculty this past year. Yes, we're very grateful. Vivek has done really pioneering work in the world of technology and human rights, and directs our technology policy clinic. And last but not least is Andrew Coan. Andrew Coan is not only the Associate Dean for Research at the University of Arizona, he's also an eminent professor of constitutional law, where he writes a lot about constitutional theory. So we're really honored to have this distinguished group of panelists here today. So what is this panel about? Well, if you were unfortunate enough or fortunate enough to see my keynote, you saw that we're now in a moment where large language models like GPT-4 can interpret any legal document you give it and give you an answer. So we saw in that panel, we took the Third Amendment of the US Constitution, and we asked it various questions about which the Third Amendment on its face bars the government from quartering soldiers in your house, forcing you to host them. And then I asked them, I asked GPT-4, would the Third Amendment bar the governor of Colorado from being forced to be quartered at my house? And GPT-4 said, no, the Third Amendment gave me an interpretation, only applies to soldiers. But then I asked another AI system, another frontier model, Claude 3 Opus, and I asked it the same question, and it said, yes, the spirit of the Third Amendment is that the government is prohibited from imposing any legal officials, not just soldiers, but anyone from the government, right? So we had our first AI circuit split there, but that was meant to illustrate a larger point that these systems will give you interpretations and confident interpretations, but in the background, there's stuff going on. There's different value judgments and assessments, and we are in a world where we need to talk about this because the hypothesis is that certainly judges out there, I don't know about them personally, but you got to imagine in their chambers when the lights are dim, they're typing things into GPT-4 and asking what's the proper interpretation of this contract term, reasonable efforts or not, what's the ordinary meaning of this. And there are some benefits and some costs. So we're going to talk a little bit about this, but proponent have said this is a good thing, right? So what we have now is maybe a judge somewhere who has to interpret a term like reasonable efforts, but what does he know? Maybe slipping through a book, kind of looking through some customs. They're kind of doing this ad hoc, arbitrary decisions. You know, maybe it's a new judge, maybe they've seen, but on the one hand, this is maybe kind of arbitrary. Same thing from the Constitution. So proponents of this said, yes, AI will allow for more consistent, principled interpretations. Judges aren't exactly principles. On the other hand, critics have a lot of things to say about this, that this notion of objectivity of interpretation by AI is illusory, right? So, you know, behind every interpretation, whether the Third Amendment applies to only soldiers or the governor, is a value choice. It's an interpretation, and under the hood, something's making a value choice, and we should be aware of it, these interpretations. The critics also highlight the central role of humans in legal decision making. Like, humans are important to make decisions about other humans, and that's you know, a central principle of law. And others argue, wow, we've already had this debate before in plain old constitutional law before AI even came along. We have different interpretive philosophies. Some of you who are lawyers, but others who are not, there are different interpretive methods, things you might have heard words like originalism or textualism or structuralism or pragmatism. Like, these are, and we've had these debates over and over again where some people says the text tells you everything you know, and others say, no, you have to take into the context, or, and these debates don't settle anything. So this is where we are. We are in a moment where AI can read legal text, and I want to emphasize, like I did, they couldn't 2 years ago read it at the same level. So this is an interesting moment. We couldn't have had this conversation as reasonably as we did 2 years ago. So I'm going to ask the first question to Andrew Coan. As a constitutional law scholar, how do you think about the use of AI in the interpretation of the Constitution? And is this a tool that will help ameliorate some of the seemingly intractable political or social disagreements about law in the US, or is this illusory?
Thanks very much, Harry, and thanks to all of you for coming to this panel and to everyone who's helped to organize this conference. It's really a pleasure to be here. I've spent quite a lot of time and quite a lot of my career thinking about constitutional interpretation and a little bit of time thinking about artificial intelligence and large language models. So I'm going to offer some tentative thoughts here about the intersection of those two issues or questions, and really look forward to hearing from my other co-panelists, who I suspect are all quite a bit more technologically knowledgeable than I am. I want to raise just first a couple of questions and then offer some tentative thoughts on this last question that Harry posed, because I think when we talk about the use of AI, and here I'm going to focus specifically on large language models and the use of in constitutional interpretation, we need to be a little bit careful about what we are talking about and what we are imagining. There are a lot of different ways in which LLMs might be used in constitutional interpretation. Are we talking about the use of an LLM as a research assistant in a judge's chambers? Are we talking about an LLM that is being asked to predict how a court is likely to rule by a lawyer or someone who has an interest in the outcome of a constitutional dispute? Are we talking about an LLM that a judge is asking to decide a case in some kind of global sense? Tell me the answer to this constitutional question. Are we talking about a more narrow use of an LLM to decide a case under a particular interpretive philosophy? Tell me how an originalist would decide this particular case, or maybe even a judge using an LLM to ask or to answer a really narrow question, which is part of, but not the whole answer or the whole of what we need to decide a particular case. I think all of these different uses probably have different pros and cons, and it's pretty important as we think about this question to just aggregate these various uses. Another, I think, important point to keep in mind as we think about these questions is that constitutional interpretation, issues of constitutional interpretation arise in a lot of different institutional contexts. It's not only courts that confront constitutional questions, lawyers and clients confront constitutional questions, lawyers within the executive branch of the United States, for instance, and within various governmental departments at all levels of government encounter these questions, wrestle with these questions, even in contexts where no dispute ends up in court. And of course, these questions arise at different levels, even within the judicial system. The kinds of constitutional questions and the resources available to a district court confronting a constitutional dispute are different from the kinds of constitutional questions that are most commonly presented to the courts of appeals, which are different in turn from the kinds of constitutional questions which are most commonly presented to the Supreme Court. Among other things, the constitutional questions presented to the Supreme Court of the United States are typically involve much harder issues on which the existing law provides fewer determinate answers and in which there is a wider range for plausible or reasonable legal disagreement. And I think the use of AI in these various contexts raises different questions, and it's important to keep those distinctions in mind. Finally, I'll just offer some tentative thoughts on the last question that Harry posed. Do LLMs or artificial intelligence offer the hope of achieving what is, you can think of as a kind of eternal, although up to this point unrealized dream by at least some thinkers in the realm of constitutional interpretation of providing some kind of objective, externally valid approach to resolving constitutional questions that allows us to squeeze all moral judgment out of the process. And you can probably tell by my phrasing or framing of the question that I'm pretty skeptical that this is likely to be the case. One of the reasons why I think I'm skeptical here is that, of course, the choice to use an AI which is trained on a specific data set which embeds, as many other panelists have already discussed here, a number of predictable biases is itself a kind of moral judgment or moral decision. It might be the right moral decision in some contexts. It might be the wrong moral decision, but it's a moral decision nevertheless. Maybe somewhat less obviously when you pose a constitutional question or a question of constitutional interpretation to an LLM, as when you frankly pose a constitutional question to a human interpreter, the way in which you frame that question has a lot to do with the answer that you are going to get. I spent a very pleasant Wednesday afternoon this week posing the verbatim questions presented in the Dobbs versus Jackson's Women's Health case and the Students for Fair Admission affirmative action case to Claude 3 Opus and to ChatGPT 4, just as a small illustration of how this might work out in practice. I first asked the two models how they would decide these questions without giving any guidance about what sort of interpretive philosophy they ought to provide or what they ought to apply. Interestingly, both of them would have decided these cases in the opposite way that the US Supreme Court actually decided them. Dobbs was wrongly decided according to both ChatGPT and Claude Opus, as was the Students for Fair Admissions case. I then asked them how they would decide these questions as of June 1st, 2022. So based on the state of the law when these cases actually came before the US Supreme Court. Under the interpretive philosophy of Justices William Brennan and Thurgood Marshall, or justices like them. I asked them how they would decide these cases as an originalist. And then I loaded the dice a little bit and asked them how they would decide these questions as an originalist, but with a thicker, fuller, more academically sophisticated explanation of what an originalist approach should entail, with a particular emphasis on one of the theoretical ideas to emerge from some of the most recent literature on constitutional originalism, which is the idea of linguistic indeterminacy and basically that the constitutional text does not necessarily resolve, the original public meaning of the constitutional text does not necessarily resolve all questions, pushing the model to reckon with and grapple with the existence of indeterminacy in the original public meaning and the need in some cases where the original public meaning of the text runs out to supplement that meaning with additional considerations like judicial precedent or historical practice or prudential reasoning. And by pushing the model in that direction, I was able to to lead the model to reach the opposite results that it reached under a more straightforward and bare bones description of originalism. When I asked it to decide these cases as an originalist, it decided Dobbs the same way that the Supreme Court did, it decided students for fair admissions in the same way the Supreme Court did. And when I pushed it to grapple with the indeterminacy of the constitutional text and the original public meaning, it flip-flopped. Then I did a little bit of further experimenting where I tried to persuade the model that it had been wrong when it gave me, in the original answers that it gave me under each of these various interpretive approaches. And in each case, it was trivially easy to get the model to reverse itself based on a very basic, one paragraph summary of the opposing arguments on the other side of the case. Harry told me after I engaged in this little exercise that there's a name for this phenomenon. It's called AI sycophancy, where the LLM tries to please the user and to give you the answer that you're looking for. And I think that's actually a nice place to end. If the dream is that artificial intelligence and LLMs will provide some kind of objective basis for resolving our disputed questions of constitutional interpretation, and one that will allow us to squeeze all moral judgment or bias out of the system. The ease with which it's possible to lead the model to your own preferred outcome, I think is at least a pretty strong cautionary note about that prospect given the state of the existing technology. So with that, I'm very happy.
Thank you, Andrew. Let me just summarize a couple of themes in your terrific overview there. That was great. But I heard a couple of themes is, one, despite the illusion, AI will not relieve us of the burdens of judgment. And indeed, an interpretation done by us or the AI is still making explicit or implicit value choices about some issue in society. So that doesn't magically go away. So that's a great point. Another point I heard you make is the sensitivity of these models and the lack of repeatability. So it's well known that a lot of these models have intentional randomness built in. That's actually a feature, not a bug. It's designed to stimulate creativity. But this only enhances the idea of understanding the limits of these models, because you could easily imagine a judge saying, I am a textualist. What is the textualist answer to this? Seeing an answer and being like, wow, okay, here's the answer, not realizing that the specific words they put in are kind of leading it down a particular path, and they might get a very different answer if they left out the word textualist or they framed it differently. So this lack of repeatability. So making the legal profession aware of that they're not getting objective answers, they're getting sort of the illusion of strongly stated answers that are very sensitive to initial inputs. Let me open this up to the rest of the panel. Let's focus on the common law questions, and we'll turn more to like private law documents. Vivek, you look like you're raring to go.
Oh no, I'm just I'm absorbing what you were saying.
Yeah.
But on the point of repeatability, and I guess it's for everyone to think about, right? If we think about the legal system as a system, right? We do have, and how cases move up the system to ultimately the Supreme Court. Maybe that feature is a feature, right? In that we have different AIs and different runs of the model coming up with different answers, which is not dissimilar to how trial court decisions, you form a split that goes to the circuits, et cetera, et cetera. So I don't know how we grapple with that.
So I think the difficulty of getting the AI to settle on a particular answer, getting different models or different LLMs to converge in a single answer could have some kind of utility in helping us think through the array of possibilities. But I think it underscores the extent to which the AIs are simply going to present us with new occasions for the exercise of moral judgment rather than allowing us to avoid the burdens of judgment, as Harry put it.
Megan, did you want to weigh in?
Yeah, so I think basically what I'm hearing from you, Andrew, is that right now, it seems a little bit unclear in terms of the user persona that's involved in kind of the use of these tools. So when you talk about kind of asking these questions and feeding it this judgment, like, is it a law student that's kind of undergoing this exercise, right? And kind of like trying to play out different scenarios, or is it actually the judge who's kind of focused on looking at a specific scenario? And why I find that kind of interesting is because historically, some of the predecessors to large language models, the transformers itself, we've seen, there's a paper out by Dan Katz a while back called Natural Language Processing in Law. And a lot of what they showcase is that pre-large language models, a lot of it was very, very task-centric down to, they were doing exercises involved in information retrieval, on prediction, and all of these things that you've mentioned, they're sort of rolled up now in a new feature known as natural language generation, and where you're seeing kind of a lot more of a dialogue, right? And I think the dialogue and the kind of use of chatbots was the moment of spark, right? Where suddenly, it was much more interactive for the average person to be able to now reason with the US Constitution. And so to me, I think the question is as opposed to kind of the back end, me kind of using this tool to retrieve some sort of information, a one-off kind of task, because of this continuous iterative process, I might think that a use case that makes the most sense here is strategy and gameplay, right? It's kind of a transition now from just only doing tasks using these models to now thinking like, oh, I can work at a higher level of abstraction and start to think like if I'm using them and integrating kind of my own judgments, I'm looking at what are my abstract goals here and trying to navigate that space. And I think that that is probably kind of a distinguishing factor in why these models are so fascinating, why there's all these prevalent risks, is because it's no longer as specific as I want to retrieve one kernel of information on what this interpretation of this text means, or like I want to look at all of these texts and find maybe a common pattern. What it is now is that there's constant back and forth and constant iterative feedback that is going to change the way that I'm going to make judgments.
This is a great point, and some of those themes echo the format which Professor Chris Goodman mentioned yesterday, the sort of automation bias and automation deference. If something comes out of a computer, we see it as if it's mathematically correct somehow, where we might not give that same deference to a judge or somebody who might be expressing their opinion. I wanted to say, does this Vivek's comment resonate at all with your Silicon juries idea, or?
Okay, so maybe a word of introduction. I dedicated myself over the last couple of years thinking about how we can build AI tools for a better legal system, a more equitable, more access to justice. And so when I hear the problems that were presented, I say, yes, these are problems. But my reaction is challenge accepted, right? Can we solve these problems? Yes, there is a true problem with cacophony. Like the model will play along to your questions. There is a question of prompt engineer. Are you capable enough of articulating your question in the right manner? And what happens to the sensitivity of the model? When you change a word, would that produce a different answer? What about randomness, right? That's like a part of the thing. Can we find tools, think about these problems proactively and think about how can we build better tools? And the answer is, yeah, there are means of building better tools to address all of these questions, but there are more questions, and even these questions have nuance. One thing we can do is, listen, these things are not expensive. We don't have to ask them a single time and just satisfy ourselves with the first answer we get. We can ask them 1,000 times the same question. I mean, we can't do it to a human. That will be kind of not nice, but we can do it to an LLM. Their patience will never run out, and we can collect the answers and we can see if there's trends in the data. We can freeze the randomness by setting the temperature to 0, and then we can freeze the model and produce every time the same sort of answer. And so all of these are problems that if you're sufficiently motivated, we see that we have an opportunity here to build better legal tools. We want to be motivated and take all of these questions and respond to them by building better tools.
So I'd love to follow up with that. So some of your work, so we're moving now outside the constitutional law context to interpreting civil documents like contracts. And you've made the case that using AI to interpret contracts might provide some benefits. Can you say a little bit more about that?
Yes, absolutely. So these tremendous models that are trained on vast amounts of data, Llama 3 came out yesterday, 13 trillion tokens. That's just mind-blowingly large. It's more text than any of us will ever read in our lifetime. So how can we take these models and create interpretation machines that improve our current processes? Part of my work with Professor Dave Hoffman of the University of Pennsylvania, we have developed a notion of the idea of, or methodology of generative interpretation. Generative interpretation is exactly building the tools that think and are aware of these challenges, and we use them to probe those large language models and try to extract their understanding of language. So what do? We take a bunch of famous difficult cases in contracts mostly. We present them to the model and see how they reason about them, how they understand the language, questions of interpretation. For example, we take the Katrina case. If you remember, Katrina left sort of devastation, wave of devastation in New Orleans, tremendous suffering and tremendous loss of life and property damage. And then came the lawyers. And so the question became part of the litigation question was, can you sue the insurers for flood damage given that the insurance policy excludes flood? And this is the last thing I'll say about insurance policy because, we're after lunch. So. And the question, is that flood? Because the argument was the plaintiffs wanted to push forward the argument that it's not a flood if it's man-made. If it's flood, if it's rain damage, but not if the levee's broke and that's negligence. Human negligence doesn't count. Like the word flood doesn't encompass natural causes. That was the argument. It was a very creative argument. And the Fifth Circuit said, no, it's not going to work because flood does cover all of these sources. And many people were very critical of the Fifth Circuit. They said, well, listen, you're just reaffirming your pro bono business priors. You're not really doing textualism. You're not truly trying to interpret. What if we can take large language models that are impartial, that are reproducible, that we can, are very convenient to use? You alluded earlier to judges using them. We have surveys showing that judges actually experiment with them. What if we can take these tools and try to see how they understand the word flood? And what we show is that the court has actually got this one right, at least according to some definition of correctness, that the word flood as it is understood by large language models does encompass artificial and man-made, and natural and man-made sources. And you can use it for many other cases. There is a Supreme Court case, for example, Pulsifer came out very recently where there was a question, can you read this document in more than one way? And the majority says, no, there is no ambiguity. You can only read this statute in a single way. And you present that to the large language models and you see that the way they understand language is actually quite ambiguous. We also see it in surveys when we survey people, but it's very difficult to survey people for every question of interpretation. We can do it with LLMs. And in both cases, we see this sort of ambiguity emerging. And that's a very powerful tool, we think, for judges when they're very certain about the way they read language. It's sort of a check to say, well, maybe this language is open to multiple interpretations. And I want to expand also the view of who's exactly interpreting legal documents. I mean, we typically think about judges, in their chambers trying to picking dictionaries and trying to understand language. But legal interpretation is a task that we all engage in. Regulators engage in, citizens engage in when we're trying to abide by the law, we're trying to perform our contracts. This all involves a measure of interpretation. And we have a problem there in contracts, which is my main area, that people don't read contracts, right? They're too long. People tell me they're boring. I take offense to that. And what we've done, we experimented with, hey, can we use LLMs as smart readers, like your smartphone? And what we show is that, what we found is that you use LLMs, you take all those long terms of service, all the iTunes privacy policies, you cut them down by almost 60%. You shorten reading time by 14 minutes and 49 seconds on average. That's quite significant. You reduce the level of the text from a college level to the level of a 5th grader. And guess what? You're not missing any critical legal information as evaluated by experts. So we see tons of potential, and when I'm so motivated to think about your problems as challenges rather than fundamental problems not to think, and I'm not saying this is how you put it, this is what motivates me. I think we have a great tool and we can build stuff, and it's not a project for any single person. So I invite all y'all to think with me about that.
These are some great points. Thank you, Yonathan. I want to pass this off to the panel in a minute, but I'll just summarize some of the themes. So one theme is you might have strikingly different considerations in the private contract context than you do in the public constitutional law context. So we might be more willing to engage, in contractual interpretation by AI versus constitutional interpretation, which might affect the entire country rather than individual people. Another thing I heard is we shouldn't automatically assume that judges are error-free and excellent, right? So who knows what the Fifth Circuit has their own opinions about things these days, and in particular, if they interpret the word flood, who's to say that their interpretation is rigorous or transparent or not motivated? On the other hand, I was reminded of the idea where you said that the LLM agreed with the Fifth Circuit, whether you did experiments to test for the sensitivity of the input and whether, if you rearrange the prompt slightly, it might come out with different. But your point is well taken, that that is at least a useful tool. And then third, I heard this idea that it might educate judges who are maybe have narrow focus, that there might be more than one way to interpret things by putting it through the LLM that can show you there's ambiguity you didn't see. So let me pass these questions out to the panel there.
I can start. Thanks, Jonathan. This was really interesting. And I think you've prompted me to want to clarify something about my own remarks, which is just that none of the issues that I was discussing at the end of my remarks is one that I see as necessarily an insurmountable problem, maybe not even a problem at all. It just seems to me that we should be clear about, given at least the current state of the technology, the extent to which moral judgments of the user of AI in any particular context are likely to play a role in the outputs that we're getting. So I'm curious, a couple of questions, whether you see the large language models in the context of contract interpretation as a route around moral judgment by humans, or simply as a really powerful auxiliary to moral judgment by humans. And second, just to follow up on Harry's question or observation, I'm curious how much testing of the sensitivity you did, in particular, how much you attempted to talk the AIs out of their original answer, because it seems, based on my playing around, I think your study was much more systematic than my little noodling around on Wednesday afternoon. But my intuition, based on my own experimentation with the models at this point, is that any reasonably competent lawyer can pretty easily talk them into a different result by emphasizing, for instance, the context in which the word flood is used and the assumptions that people reading an insurance contract might have about what would be covered and what would not be covered, and the role that under modern linguistics or the philosophy of language, we understand context to play in linguistic communication and the formation of ordinary meaning of a document, and so on and so forth.
Yes, so no surprise that I actually agree with the sort of motivation behind your questions, with like, hey, how far can I push it, and what happens when I push it? And that's such an important question, right, for the legal process. We want to make sure that the outcomes of legal cases reflect the merit of the case, and not so much the identity of the parties, or maybe you have a super powerful attorney who can frame things ever so powerfully. And well, the truth of the matter, part of what we're teaching here, our law students, is exactly that: how to prompt engineer humans, how to frame your case such that it'll be compelling, right? So, And that's maybe also sets the ground for for a point that I think get lost very, very frequently, which is to compare to what, and this is a normative judgment, but I don't think our legal system right now is sort of the best anyone can ever aspire to in terms of truth searching or vindicating justice. I think there are many structural problems we have today. And when we are critical of the models, we should also say, it's not good, but is it better? Not rather whether it's the best option we have. Now, well, one more point about that. We want to make sure that when we ask a model a question, we get an answer that's not very very sensitive to the prompt. And we can do it, we tested it. And we imagine a world where both parties will present many different prompts to the court, and the court can say, well, here are 1,000 different prompts we're checking, and we're seeing what is the correct interpretation of flood, or what is the major trend within all these different prompts. And one of the beautiful things, we can do that. That's something that actually can be done. We cannot do the same with jury instructions. We send a question to the jury. We frame it, we use words. These words decide the case many times. You can imagine different jury instructions, and in fact, this is part of litigation, fighting over what goes out to the jury. We have one chance. We have freedom when it comes to LLMs to experiment more. Now, in terms of moral judgments, generative interpretation, as we think about this method, is one half of the interpretation project. Interpretation is not just deciding what words mean, it's also what they should mean. And here we imagine that this is where the judge steps in. This is not about replacing the moral judgment, but there, I think in your comments and in your question, there's like, well, when we decide language, there is some normative element involved. You can really prune the normativity or the ethical judgment from deciding the meaning of words. And here I have one sort of reassuring finding from recent literature. The literature on silicon sampling, or I work on silicon juries. It turns out people have started asking, hey, instead of surveys in the social sciences, can we ask LLMs to be our respondents? You know, all these like polling questions we read. Can we use LLMs instead of flesh and bone humans? And before we do that, we want to make sure that the responses actually correspond to what humans think. And the finding so far is that LLMs are actually kind of good in getting broad dispositions, like what Democrats think about Republicans. They can capture it quite well. They cannot capture well any sort of nuance. This is what would a Democrat from Chicago would think about a Republican from, say, Alabama. Like, yeah, okay, they don't do well there. But there is, they do encode and embed moral judgments into these models that correspond either through the training data or RLHF to actual human judgment. So there is some reason to be optimistic.
Yeah, that's a great point. And it does echo some of the themes we heard yesterday of if we're going to do something like that, we want to be concerned that the training data is representative of different demographic groups where it is at least historically been skewed and not representative. Let me pass this out. Megan, did you have a comment on the question originally directed at Yonathan about the benefits?
Yeah, so I know Yonathan doesn't want to talk about insurance, but I guess I will. We have an insurance initiative over at the Stanford Center for Legal Informatics, or CodeX. And one of the current tools that we've been working on with reinsurers is actually this notion of elasticity. So it's basically how and why we stretch our words, so not in the economic sense. And really, it's supposed to be a play on vagueness, right? When and why do we use vagueness? And can we detect actually moments of intentional vagueness versus unintentional vagueness? And the idea is that unintentional vagueness is actually costly, especially for reinsurance, which for folks that don't know, it's actually insurance for insurers. And so the risks are really at stake here. And one of the things that they frequently talk about is this notion of silent risks. Did I craft my policy such that I inadvertently wrote in or am covering some sort of risk that I don't want to. And so we built this tool that essentially kind of breaks down the clause and identifies all these moments of high elasticity. And then we kind of allow these underwriters, so the contract drafters, to actually say, oh, yes, this is a moment of elasticity that makes sense given the fact that, you know, we value these long-term relationships and these highly negotiated contracts, or this is like business operations as usual. This is just the typical language. And essentially these models are really great at sort of giving almost like a write-up and a quick report to illuminate kind of an alternative perspective as to whether or not the underwriter actually was vague in the way that they want it to be. And it kind of gave a better lens, a secondary pair of machine eyes, so to speak. And I think that that's really sort of pointing to Yonathan's point of like, with these large language models, it's not just kind of enabling interpretation, it's also actually helping the folks that are in the drafting position, that it's more than one user at play, and it's really about the use case that we're working with here. So, so even if, you know, flood is, we always think, you know, insurers are the bad guys, but if we offer tools like this, maybe they have a little bit more clarity as to how they're writing these contracts.
That's a terrific point, Megan. So those who are in the law know that ambiguity and vagueness is not always a bug. It's sometimes a feature. So it's thought of outside the law. Why do you have a word like reasonable, something like that? But within the law, often that gives flexibility and judgment and discretion later in time, and that can be beneficial. On the other hand, sometimes vagueness actually and ambiguity is a bug, especially if you didn't mean it to be there. So I love this idea of using AI as almost like a vagueness spell checker in a sense that helps us. Do others want to weigh on this idea about using AI in this context and, intentional or unintentional vagueness? Any thoughts? All right. So Vivek, so one of the themes that has come up a bunch is that we sort of framed it as this is a judge late at night when nobody's around using GPT-4, right, secretly. But that's not really the way it is, right? One of the real benefits is that lots of different users can use GPT to maybe understand the law and make it more accessible. So I want to throw it out to you, Vivek. Tell us about the different contexts in the law in which AI, large language models, can be used and some of the benefits and risks of that.
Yeah, absolutely. Thank you, Harry. Thank you, Silicon Flatirons. Thank you, all of you, for being awake after that great lunch. So let me begin with a question. Who here is a lawyer or has legal training? So about half to 60% of you. Congratulations, you represent 0.4% of the American population. And we are the country that has by far the highest rate, per capita of lawyers in our society. So we're really not following Shakespeare's advice on killing all the lawyers. Okay, so here's where I'd like to start. It was tax day this week. I hope you all filed your taxes. And, Donald Rumsfeld, the former Secretary of Defense, every year, may he rest in peace, would send this letter to the IRS saying, here are my tax returns. I have no idea if they're correct. I'm a college graduate, and I can't tell because our tax code is so complicated. That's terrible. It reflects a travesty that, a well-intentioned person can't tell if they are filing their taxes. I'm a law professor, and I also file my taxes. I have no idea if they're accurate or not, but I did rely on a tool. I relied on TurboTax, right? Which is an earlier instantiation of AI. So go back to Harry's point this morning about the different schools and the history, right? It's an expert system as far as I can tell, right? Someone went through and programmed at least some of the tax code into TurboTax, right? And there's points where you hit it and say, I can't help you with this foreign tax credit, right? Go talk to a human at this point, right? But we've encoded the law in a primitive way, in a way that actually produces very high quality results that compare very favorably to the best accountants or tax lawyers in the world. So I'd like to make that my starting point about how we think about AI in the law, which is that, and this builds on Yonathan's point, right? Which is that everyone in society makes legal interpretations and legal decisions and has to follow the law. And the law goes well beyond the Constitution and the statutes and the rules. It includes building codes, right? When I'm deciding, can I do this electrical work by myself at home? I probably shouldn't, but there's law around that. And to the average person who is not an expert in a particular area of law, not only is the law unknowable, just the fact whether there's regulation that applies to that question is often very difficult to discern, right? So I think we've sort of focused a lot on, again, what Rumsfeld would call the known unknowns, right? The hard questions, right? How should the Supreme Court decide Dobbs? How might it do that? And those are a very, 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 very small percentage of legal questions that arise in society, right? They are the very top of the pyramid. Even things that make it to a court, I would argue, represent a long tail on the distribution of legal questions that come up in society. So to me, the fact that all of us in a society of rules, and there are so many rules, have to follow these rules and interpret them, creates a tremendous opportunity for better legal tools, right? Tools to uncover the fact that this is a regulated area, and tools to give us first approximation answers to questions that are probably very easy for experts, right? So my tax situation in the realm of tax situations is probably pretty simple. You know, I don't have anything crazy, but it was hard enough for me, right? So we can think about that across many different fields, right? Fields of technical regulation. We can think about frontline government officials that have to make decisions that sometimes implicate constitutional values, right? Can I stop this car, right? Is this a search incident or arrest? Those are all questions for which, you know, arguably there's actually quite a bit of settled law, and that 99 trial courts out of 100 would probably resolve in the same way. But again, to a person without legal training or expertise in a particular area of law, those simply can't be resolved, right? So I think thinking about the application of AI in outside of contentious cases, thinking about compliance, right? And a lot of what lawyers do in practice and what people who are in regulated fields do is attempt to comply with different kinds of rules, right? Some of them have legal force. Some of them might be professional standards, codes of ethics, you name it, right? Engineers are a regulated profession, as are doctors, as are dentists, as are everyone else. So I think that's an area where we really should think, and I think it's an area where it's perhaps less contentious, right? Where we could actually look already at a system like GPT-4 and find probably convergence on the answer to these easier questions, because they are easy and they are more settled, but they're still unknowable and undiscoverable to folks without that expertise. So the last thing that I wanted to point to is that I do wonder if there's an opportunity beyond the sort of Q&A function of something like GPT to either surface rules or to help provide some, you know, let's say easy legal advice, to rethink how it is that we apply law in society, right? So I'm going back to my tax example, right, where we have a form, an extremely complex one. I'm a naturalized American citizen, and let me just tell you, that was a hell of a thing to navigate. And I look at people who have like no legal knowledge and perhaps limited English proficiency and say, man, how the heck did you navigate that system to get your green card or whatever benefit it is? So obviously there's a lot of innovation happening in terms of access to justice, in terms of building better forms, building better legal tools to allow people to access benefits. But to me, I wonder if we move our focus away from legal decision-making to a compliance orientation of helping people follow rules or seek benefits to which they're allowed to and leverage these technologies, if we may get more bang for the buck, if we could really improve the quality of justice and of access to justice in our society, and perhaps avoid some of the harder legal questions that ultimately we are going to want to have humans decide for those moral reasons that I think we've been surfacing in this panel, because they do involve hard moral calculations. But again, filling my taxes out correctly should not be that kind of decision.
Great, Vivek. That was terrific. So just to sum up a couple of things, maybe we would imagine if Rumsfeld were still around today, this year he'd be writing the IRS. This year, I finally understand the tax law thanks to GPT-4. Thank you. And another theme you brought up is You make a great point. So the scholars from the science and technology studies systems and other allied fields have been writing for years that socio-technological systems embed values. So something like TurboTax, they read the tax code, implemented it in some system, but those are value choices that we just talked about, not unlike saying that the governor is a soldier because a soldier really is a proxy for government official. So if they list something as a business expense or not, they're making a decision. So value choices get embedded one way or another, and there may not be any way to avoid them. And then the final point I really liked is in law school, of course, we focus too much on judges, and we shouldn't. But we're all citizens governed by the very laws around us. So this is the idea of the law of the ground, law on the ground, and a lot of these day-to-day decisions may be way more impactful than the output of GPT-4 on one judge's interpretation. Let me throw the same question out to the rest of the panel. Yonathan, you had echoed some themes about different user, like outside of judges, different contexts. I saw some other thoughts out there.
Not just echo, if I could, I would say the same thing. Because I think that's absolutely right. I think the barriers to access to justice are huge, and some of them are artificial. And I have a question for you. We have, in the context of unauthorized practice of law, we have decided as a society that getting legal advice from someone who does not have our level of experience, does not have our license, that is impermissible because they might get the wrong advice. You make the point that there are so many decisions in our lives where the stakes are not that high. The cost of mistake is not very high. And so even in the rare case where GPT-4 might hallucinate, or at least maybe this is how I'm understanding you, is we're still like, that's better than the status quo where people just don't know what the law is. But I can imagine a near future where there will be a strong push to make legal advice via LLMs illegal. Unauthorized practice of law, and there will be cases, I'm sure there will be cases of people who've lost significant economic rights because they've relied on bad advice from GPT-4. How do you think we as a society should decide on whether LLMs should be given the permission to even generate legal guidance?
So I think there's a few different ways of thinking about this, right? First of all, I will say that I think the unauthorized practice rules are extremely restrictive, and that admission to the legal profession is too restricted in many ways. And that, again, I am completely incompetent to give you family law advice, despite the fact that I'm a member in good standing of the bar of the state and of several others, right? So don't come to me with those questions. So the UPL rules are not, first of all, actually an effective check on competence, right? We use other mechanisms to govern the competence of lawyers, which that even if you're duly barred, right, can you actually ethically give this advice? But there is a distinction that we've long drawn between legal information and legal advice, right? So I think where it might get interesting is to think about feeding into GPT a series of facts and saying, give me advice on those facts, as opposed to the issue spotting, right? And even if we were comfortable with a regulatory framework whereby we could provide issue spotting via automated means, I think that would be a win, right? To say that actually, you might be violating some laws here. There might be some relevant regulations. Here's what they are. Go talk to an expert on this, right? But so to me, but I just want to build Harry's point, right? Think about systems, right? Socio-technical systems and the law as a system, right? And all of its functions, the regulatory functions, the way that we furnish advice. Nothing in the status quo necessarily needs to be that way, right? And other societies do have different ways of provisioning legal advice. So, in civil law societies, notaries do a lot of stuff, right? They're less regulated. It's easier to become a notary, and they can deal with entire classes of legal issues much more quickly and efficiently than a lawyer would, right? A lawyer would deal with something contentious. A notary would draft your will and draft a contract and do this and do that, right? So I do think that as this, it's coming, right? The systems are going to generate this advice and these answers. So I think it's going to put pressure on the legal profession. That's probably a good thing because the system we have is not that great.
Anyone else? Andy, did you want to weigh in?
Yes, thanks, Vivek. That was really great and thought-provoking. I wonder if we might, from the discussion as a whole, and in particular from your presentation, distill, and whether you would agree with this distillation of a couple of principles where, for thinking about when the value added of LLMs might be greatest, at least as compared to the alternatives. And two points that that stood out to me from your presentation are that in contexts where there are relatively clear answers, the value of LLMs versus more costly alternatives, and almost every alternative is going to be more costly, might be quite high. And second, in contexts where the stakes are relatively low and where the number of impacted persons is relatively small, this too might be an area where LLMs have greater value added compared to human alternatives or some combination of human legal expertise and LLMs. And I wonder if you would endorse those principles and whether there are other principles that you think might emerge from your account.
Yeah, so I think that's exactly right. I think there are some areas of the law where answers are relatively clear and the stakes are relatively lower in terms of the affected parties or the impact of something. And I would just sort of look at where we have, let's say, low-cost sources of legal advice. So look at forms, right? Standard forms. Think about, the NOLO series of books, How to Write Your Will, right? Are those areas of the law where people need legal advice, right, to structure their affairs or some clarity about what they're doing, in which automation could really help? And I'm not saying that necessarily the models of GPT that we have right now that are the OpenAI GPT-4 as opposed to the versions that are made specifically for the law with more safeguards and or other approaches to developing these systems, right? I think I'm open to all of those possibilities. Like, what if we did use an LLM to help us develop better expert systems? Like, that could be an interesting approach to say that here's a system that we've developed for family law problems, right? Where we've used LLM to identify a range of issues that come up in large corporate text, and then we devise a tool that helps people navigate the systems, right? So that could be an approach to improving access to justice within that area of like lower stakes, lower impact issues that would have considerable benefits in my view.
Megan, did you want to weigh in?
Yeah, so I think one of the interesting themes that sort of surfaced is how well actually do these models perform relative to lawyers? And if we're saying that, lawyers are kind of the beacon behind who we should seek legal advice from, can they really, have the kind of credentials to stand behind that, right? And one of the efforts that actually we're working on together, Harry, is this benchmarking effort, right? To actually, and a lot of the literature out there right now, you've seen all the flashy headlines like GPT-4 passes the bar, ChatGPT goes to school, all of those things. But what's been missing from these empirical studies is that it has not clearly actually performed a legal task that lawyers kind of do on the day-to-day basis. We don't actually then have a realistic metric between what is good legal work versus not. And so one of the things that we're trying to work on here is we're doing a blind evaluation, and we've partnered with DLA Piper on this, where we'll have a set of sort of mid-tier, not mid-tier, but like mid-level attorneys 3 to 5 years. And they're given a legal task that they do on a day-to-day basis. We give that task as well to GPT-4 or whatever set of state-of-the-art models. And then we ask senior partners to blind evaluate to see what their preference is. And I think a lot of right now what we evaluate these models on is purely on this dimension of accuracy. But for many lawyers, accuracy actually is the synthesis of the information and then kind of driving a good argument behind that, right? It's not accuracy from like the binary of a yes/no answer. And so doing this type of benchmark actually could probably anchor us better in how far off are we actually from these models doing legal work and performing our legal tasks, and where can they actually work together with us as kind of our handshake of human-machine colleagues. And so that's kind of a little bit about how I'm seeing it is at the moment right now when we're talking about these simple tasks, these easy tasks, and being able to kind of outsource certain legal activities to these models, we should first kind of have a better metric around, where are those easy tasks kind of located? And Harry's done a great job in kind of identifying all of those and doing those types of experiments. But more empirical work in this space could certainly kind of illuminate, where there is necessarily this breakdown in the argument of UPL, for example.
Yeah, thanks, Megan. That's a great point, and I just want to echo one of the points you made, which is we're very much concerned that AI models give good legal advice if they're being used by people, but also lawyers make mistakes, and only in the most egregious instances do we know when lawyers mess up, when there is either a bar complaint or a malpractice lawsuit. But in the run-of-the-mill case, when a client goes in, talks to a lawyer, and gets bad advice, in an office, we don't see that. So we want to make sure that we have some, we want the AI models to be providing solid advice, but we don't want to hold them up necessarily to a much higher standard than lawyers, where we don't really have many benchmarks on how good lawyers are, generally speaking. And then to just echo your points, one of the themes I've heard is we all have to comply with the law, whether or not we have lawyers, right? So something like 80% of Americans can't afford a lawyer for a civil matter that they have, like immigration or family law or what have you. So their alternative is to either guess, ask a friend, Google, maybe ask a trusted community member. So wouldn't it potentially be better if they're getting, I call this the advice absent baseline. They're at least getting something from an AI large language models when the alternative is just taking a guess in a complicated world. Let me throw out the final question, then we'll open it up to the audience for question. So looking forward, and remember, we're skeptical of predictions, but we'll do it anyway. Where do we see AI being usefully integrated into legal interpretation in the next 3+ years? And then how can we ensure that AI-driven legal interpretations are transparent, explainable, accountable, and equitable, especially when dealing with crucial legal documents? So this is a free-for-all for the panel. Megan?
I might start. So I think if I look at some of the analog practices around interpretation, so I come from a linguistic background, and we kind of pull in linguistics, and since it's after lunch, I'll use kind of a quirky food-related example. So there's a case that was presented before the Massachusetts court a while back, where the court actually had to decide whether or not a burrito was a sandwich. And so they decided to use actually linguistic theory on it. And specifically within semantics, they decided between componential theory versus prototype theory. And just a brief sort of overview on that, componential theory is that it's the sum of the parts is what it means. And the latter on prototype theory is, let's imagine in our mental models what's the classic example. So prototype theory, a great example is when you think about bird, you think about a robin, you don't think about penguin, for example. And so the court was trying to negotiate, a burrito is not in the prototype, and so it can't be a sandwich. And other arguments were like, well, a sandwich involves like some lettuce and whatever, and a pita bread, is that actually like the bread that we want? And so then it became sort of infinitely regressive at that point. And so that's why they deferred to prototype theory. But the implications of that case actually was that really, it was an exclusive rights case. It was a breach of contract case. And the background to that is Qdoba, I think they sell like Mexican food, vaguely, it's a fast food restaurant. They were imposing on Panera's Sandwich King territory, basically. And they had an exclusive contract with this food court saying that, I am the sole seller of sandwiches. And Qdoba, be on your way because you're selling sandwiches. And so ultimately the court was trying to decide whether or not Qdoba's presence in the food court actually, breaches this exclusive right. And so to me, this is kind of an interesting case because what we're trying to draw here is there's obviously things that are outside just this linguistic semantic theory of whether it be prototype or componential theory, right? And I think a lot of what we've been thinking about with AI is actually a focal point on context. And what's been fascinating is that a lot of kind of older linguistic techniques that have been used in court is, again, drawing from textualist or modern textualist theory and textualist methods. And we've seen, for example, the use of dictionaries, deference to external sources, and trying to draw on dictionaries as some sort of neutral source. And the other sort of newer linguistic technique that's been out there is legal corpus linguistics. And what's fascinating about legal corpus linguistics is it's sort of like very, very old school NLP, such that you're choosing a corpus, choosing just a corpus of text, for example, and then deciding kind of how it's being used, and then the words that are nearing kind of the use of a particular word. And then, so we've seen sort of a number of cases, actually in the most recent case, I think we've noticed that actually at the end of the day, the courts really are choosing linguistic theory because it has sufficient flexibility. You've seen a lot of courts like kind of go dictionary shopping, for example. Dictionaries started to surface kind of back in 1893, but the use of dictionaries actually deciding, say, between whether a tomato was a fruit or a vegetable back in 1893 was based on tariffs, whether or not, you know, you should tax a tomato as a fruit or a vegetable, and it has very, very different pricing as a result. And so why I kind of mention all of this, right, is that to me, it's almost like a natural progression into our current use of large language models. And, you know, going back to earlier, Andrew's example of context, right? What do I actually put in the context window? Or when I'm going through prompt engineering, that's that level of flexibility that's existed when judges have gone dictionary shopping, or when judges have kind of chosen the right corpus. It's about that sort of manipulation, right? And so kind of in this era now of using large language models, and context is kind of the key component, that's where we've actually learned to become a little bit more intentional. In the past, like with these kind of judgments and deference to like dictionaries or legal corpus linguistics, it almost seemed like you're kind of choosing an impartial source. And that's what the judges wanted to present in this case, right? But with large language models, we've actually become a little bit more cautious so that the intentionality of what goes into that context window, we're already sensitive to. And I think to me, that might be potentially a benefit of being able to use large language models in this kind of space, because suddenly we've become aware of, you know, the role of context and in the use of language, as opposed to just, you know, what does it mean? What does it not mean? It's actually, how is this word being used and how is context being integrated?
Megan, those are some terrific points. And I like that you reminded us that the law searching for external authorities that purport to relieve judges of the burden of judgment and mask policy decisions is been going on for centuries. Andy, did you want to make a point?
No, I just would echo what Harry said. Those are excellent observations, Megan, I think very perceptive. And I guess I would just flag the extent to which they underscore the point that I was really trying to make at the outset, which is that we are not, by using LLMs either in conjunction with or as a substitute for human judgment, squeezing these moral judgments out of our legal work. We are, in fact, making them in a different way. That's not to say that using LLMs, again, either as a substitute or as a complement to human legal analysis is better or worse. It's just to remind us that the moral judgment is still happening and that it seems important to surface that, to make sure that that aspect of what's going on is transparent, and that LLMs not function in the way the dictionaries, I think, often have as a kind of mask that prevents the public or other stakeholders from understanding the extent to which moral judgment is still being exercised.
Excellent point. All right, so I want to open this up to the audience, and our tradition is to have a student ask the first question. Do we have a student volunteer, a current student? I see some students in the back there that are very. All right, thank you. And then we'll turn it over to the audience, but this is the Phil Weiser, Paul Ohm rule.
Really interesting panel with the DLA Piper experiment that the CodeX group is running. That sounds super cool, really interesting. I guess my question is related to bias in all of these conversations. And so do you think that bias is easier to correct in AI algorithms as opposed to human judges? And if so, what does that mean for using AI to render judicial decisions or how judges should use them?
That's a great point. I mean, I have some initial thoughts, which I have hope. So right now, large language models are what are known as not interpretable. So we can't really look at their 1 trillion numbers and figure out why it produced the word Paris instead of cat, right? But I have hope in maybe in the next 5 years, based upon research, we will have more of an examination and interpretability to understand why they produced that. Whereas it's probably unlikely we will look inside a judge's brain to figure out why she, came to one decision or another. But I think right now, they're both pretty uninterpretable.
So maybe to add something about the bias problem, which is a very real problem. And it's a real problem that not because the model is not good, but because the model reflects the underlying data. And of course, when you read the entire internet, you're going to find a little bit of bias. But of course, the beauty of that, and this is part of what fuels my optimism, is that we can actually do things about it. This is sort of I hope maybe the sort of builder mindset maybe this panel shares. So what can you do? So we have the problem, we don't know in the black box, the activations exactly like whether there is bias, but we can test by having many runs and changing just the identity of the plaintiff. Does that change anything in the judgment of the model? We can do other weird things. Apparently, you can take the model and add to it mechanically, be cheerful. And then the answers become more cheerful. Be sad. And then the answers become, we can add sort of, I don't know, like surgically how that would work with humans, but we can throw in a component and tell it, hey, bias is maybe has two meanings here. Bias yourself in a way that is actually like pro-social, anti-discriminatory. We can do a lot of things that we cannot do with humans. We cannot look. Human judges are black boxes as well. We don't know whether they're biased or whether this is like their actual considered judgment. And we have opportunities here. This is why I'm optimistic.
That's a really good point, actually. It's sort of like a systems engineering approach. We can't guarantee any particular output, but over time we can say, here's the likelihood of within this range of getting certain kinds of outputs that may or may not be biased. Really terrific point. Any other comments? Another question. This gentleman has been waiting patiently.
Thank you. It's very enlightening. I have what seems to be a really simple question, and maybe it's not, but it seems like half of Coloradoans are tied into a HOA of one sort or another, or 1/3 of the country is tied into an HOA. So it's kind of a pretty huge deal as far as contract law is concerned. And we had a new old law, House Bill 221137, that Governor signed, Polis. My question is it seems to be a real gray area on the community managers not being licensed and the enforcement of covenants, and this a lot of wiggle room. There's a lot of authoritarianism, and I was just wondering, the big push is now a lot of the collection agencies are making a real feeding frenzy in all this litigation or against the new House bill, but it's for the people, as it were. It's in their best interest legally. But we're involved in still litigation, and it's thousands and thousands of dollars now. And my theme, not being a lawyer, is just ethics. So all I could do is go to legal theory here at the law school and just do the legal theory. So what's ethical, what's fair, gets into estoppel and all that. So my question to Mr. Arbel or Mr. Krishnamurthy might be, in this kind of gray area that affects millions of Americans, it's pretty foundational. What might you have a spin on that? Should these property management companies, should they be tied into AI to make it more equitable, more fair? because the licensing is wishy-washy. So it's complicated, but it would seem to be simple. So thank you very much.
So let me just sort of abstract from your question something larger, right? Which is that decisions get made about us a lot by lots of different people in contexts where there's different degrees of regulation, right? Some are highly regulated and the rules are very clear and determinate. And then there's a situation that you're experiencing of the HOAs where things, I mean, HOA has a lot of power over you, right? They can levy so huge, assessments and all this stuff, right? So to me, I think it's really interesting to think about, can we improve the quality, predictability, accuracy, and fairness of those kinds of decisions, right, using various kinds of automation? And I would say, I don't know if we can do that for sure with GPT-4 as it is today, but I'm optimistic that we can, and I think that we should, right? There's a lot of work that's done on a different kind of private decision-making and automation of content moderation, right? That's obviously something where a lot of us in this room have thought about or written about, right? Where we do actually feed in something that looks like constitutional values into automated systems to decide, does this come on, stay on or stay up? And I'm not going to take the thunder of the next panel away. But yeah, I would say that it is sort of an area that we should think about.
30-second, we're almost out of time, but 30-second reactions to the question here.
30 seconds. We have a model of how people come to assert their rights, the name, claim, blame model. And the problem we have right now is a lot of people don't know to name the problems that they face. When the HOA discriminates against someone on the basis of maybe racial prejudice or something else, people don't always know that they have experienced a legal wrong, which prevents all the downstream ability to claim your rights and fight against that. And I see huge potential for people just, hey, ChatGPT, what do you think? Is that okay for them to tell me that, I can't be outside or can have activities? And that'll be, I think, foundational. I think, intersects with your view of use case based.
Terrific point. So unfortunately, we are out of time, but please join me in thanking this terrific panel here.